In fact, here is the index of exactly what we'll be talking about. You can see that there are various aspects here. There are quite a lot of cases. We'll see how far we get. I'd like to thank Mr. Vestergaard for his presentation. I believe that I will have the same problem as him in that there are so many cases, but we'll see how the time goes. What I'll be doing is showing you some of the EU legal framework, and then looking at the cases, mentioning the details of the cases if necessary, but mainly on what the findings of the court actually were. So we'll start off with the legal framework of bad faith. Article 59 of the regulation has said that an EU trademark should be declared invalid on application to the office or on the basis of a counterclaim and infringement proceedings in two questions. First of all, where the EU trademark has been registered contrary to the provision of Article 7. Now, this concerns absolute grounds, or where the applicant was acting in bad faith when he filed the application for trademarks. So we know that there are two different things which are on the table there. Now, the first case we're going to look at is the case Stilo and Cotton. And this raised 4 different questions to the court. These relevant questions aren't supposed to represent the questions to the court, but more or less the relevant points of law that can be derived from the case. The first question was whether a likelihood of confusion is a requirement for bad faith. The answer to this was no. So the likelihood of confusion isn't a requirement for bad faith, not least because a request for cancellation on that ground can be filed by anyone without being required to be the proprietor of an earlier right. So the likelihood of confusion is one of the relevant factors to be taken into account for the overall assessment of bad faith, since other factual circumstances, such as the applicant's intention to prevent that opponent from using such a sign, or the degree of legal protection enjoyed by the latter, might be used to determine an application filed with bad faith. The second question was whether the existence of bad faith presupposes that the contested mark is registered for goods or services identical with or similar to those in respect for which the earlier mark has been registered. The answer to this was no as well. So the absolute grounds for invalidity, which we saw in the slide before, are fundamentally different from the relative grounds for invalidity, which were in Article 53(1)(a), since the latter provision presupposes the existence of an earlier trademark, as well as the existence of a likelihood of confusion, unless the earlier trademark has a reputation within the meaning of Article 8(5) of that regulation. And so, as the Advocate General observed, in the case of the application for declaration based on of invalidity, there is no requirement whatsoever that the applicant for that declaration actually be the proprietor of an earlier mark for identical or similar goods or services. The third question was whether, in the absence of a likelihood of confusion between the sign used by the third party and the contested mark, or if there's been no use by a third party of a similar or identical sign, may other factual circumstances constitute relevant and consistent indica in establishing bad faith? The answer to that was yes. So the intention of an applicant for a trademark at the relevant time, and the time is the filing of the application, is a subjective factor which must be determined objectively. Consequently, any claim of bad faith must be the subject of an overall assessment, taking into account all of the factual circumstances relevant to the particular case. And the fourth question was if the contested application was filed for multiple classes, but was, for example, due to an opposition, only registered for several of them, whether the initial classes of the application remain relevant for the assessment of bad faith. All of the initial classes remain relevant for the assessment of bad faith because the relevant time for determining bad faith is the time of the filing of the application. And so therefore those classes would still have existed at that point. So this is relatively complicated. The main conclusions that we can actually get from there is that likelihood of confusion isn't a requirement for the finding of bad faith. And also, bad faith, like other grounds, doesn't relate to an inherent defect in the trademark itself, but concerns the circumstances in which the trademark was applied for. We move on to our next case, and here we have circumstances arising outside of Europe. So just to show that this is not only confined to things which happen within the European Union. The Anne-Taylor judgment is relevant for the likelihood of confusion, as was the previous case, in that the applicant for a declaration of invalidity invoking bad faith can't be systematically required to establish the existence of a likelihood of confusion. So in this case, the applicant of the contested trademark attempted to enter into a trade partnership with the intervener and subsequently applied for a mark in Mexico identical to that held by the intervener before applying for the same trademark at the EUIPO. This constitutes a sound indication that the applicant was aware of the intervener's earlier rights. Now, this also relates to the Neymar judgment, because in the Neymar judgment, the contested trademark Neymar was filed at the EUIPO at the time when the football player Neymar played in Brazil, but was starting to gain notoriety in Europe. And the applicant of that contested mark also filed an application for another trademark containing the name of another footballer. So the court further clarifies this is because having such a requirement would render the provisions of Article 59(1)(b) ineffective, and that in any case these provisions can be relied on by any person, even if they aren't holders of prior rights, because the provisions are intended to protect the public interest. And this is similar to what the previous case, the Cotton judgment, came up with. In short, a likelihood of confusion is one of the many elements which can be taken into account in order to find the presence of bad faith, but it isn't a strict requirement for bad faith that without it would preclude a declaration that bad faith is present, obviously depending on the circumstances. So bad faith underpins the applicant's intention at the time of filing of the trademark. The evidence on file proved that Neymar was already well known in Europe, and therefore the applicant wasn't able to demonstrate that he hadn't been informed of the footballer's existence at the time of filing of the EU application. And in those circumstances, the General Court confirmed the EUIPO's decision, since there was no convincing argument to disprove that the only intention of the applicant was the desire to free ride on the footballer's renown. So in conclusion, the relevant circumstances to be considered for the assessment of bad faith to a specific filing aren't limited with regards to the time or the territories, as far as those elements arise outside of Europe. And they may evidence the applicant's intention at the time of filing for existence, nothing that precludes to determine the applicant's bad faith with regards to different circumstances. And although facts and evidence dated subsequent to the filing might be used for determining the applicant's intention, the relevant point in time for considering whether there was bad faith on the part of the applicant remains the time of the filing of the EU application. The next case, the K quota case. Here there was a business relationship between the opponent and the applicant, and this was established since the latter had been acknowledged as the only dealer of the products which came from the exclusive license which they had entered into with respect to the market issue prior to the termination of their commercial relation. Now, even though the first to file principle is commonly applied, we have to consider that an application filed in bad faith is one exception which prevents from any conduct departing from accepted principles of ethical behavior or honest commercial and business practices. In the light of the foregoing, the existence of bad faith relies on the subjective intention of the applicant based on the assessment of objective criteria. As the application of the mark at issue was filed one day before the termination of their commercial relation, this additional argument must be taken into account to determine the applicant's bad faith, since the controversial context in which the business relationship between the parties ended may confirm the intention of the applicant to usurp the rights of the legitimate trademark owner, especially when there's a conflict of interest. So therefore, the purpose of the business relationship between the parties before the filing date of the contested mark is a key element in establishing the existence of bad faith in this specific case. There are some further considerations here, though, such as whether the duty of loyalty lasts forever after the termination of the business relationships from which the applicant's bad faith could be determined subsequently. This duty of loyalty decreases in proportion to the time lapsed between the termination of the business relationship of the parties and the filing date of the market issue. As regards the ruling approved by the the General Court, when the assessment of bad faith relies on the effective compliance of the duty of the loyalty between the parties, the Court outlined the following. The fact that a long period had elapsed between the end of the business relationship and the application for registration of the contested mark militates against the existence of bad faith if this filing had a commercial logic in the light of the applicant's activities. If we go on further to other ideas of bad faith, in Article 59(1)(b), we also have the fact that other things may not be registered. Trademarks which consist exclusively of the signs of indications which might serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin of the time of production of the goods or rendering of the services. Here, what we're going to concentrate on is the geographical origin of those goods or those services. Mark in question was Swiss gear. And here we need the geographical name be currently associated with the category of goods in question or liable to be so in the future. Now, geographical names come within the scope of this, not only where they designate specific geographical locations which are already famous or which are known for the category of goods, and which are therefore associated with those goods in the mind of the relevant public, but also where they're liable to be used by undertakings and must be available to such undertakings as indications of geographical origin. So it's also clear from case law that this covers indications which might be served to designate a geographical origin or have the effect of associating goods with a place that may give rise to positive feelings. Now, in the Swiss gear case, the goods were backpacks, sleeping bags, tents, footwear, things which are basically used for camping. And the reference to Switzerland with regards to those goods could create positive feelings in the minds of the relevant public. In any event, it's necessary to uphold the finding that the evocation of Switzerland, which is associated with equipment intended for outdoor tourist activities, could implicitly refer to the mountains which, in the eyes of the general public, characterize that country's scenery and is capable of conveying the idea that the equipment could be used in an imposing environment and is designed to withstand difficult conditions and is therefore capable of creating positive feelings. So therefore, the element Swiss in the contested mark is considered to be descriptive with regard to all of the goods in question. In contrast to this, we come to the Gres Aragon case. Here, Gres means sandstone in Spanish. Aragon is a region of Spain. In this case, again, we see that we need the geographical name be currently associated with the category of goods in question. But the court came to the conclusion that, in fact, the Spanish region of Aragon doesn't actually have any reputation for sandstone. And so, therefore, the geographical term is not descriptive and the sign is registrable. So we can see the two different points of view there between Swiss gear, where there was a definite association between the goods which were applied for, and then Gres Aragon, where sandstone wasn't seen to be coming from that particular region. In Article 2, we have an explanation of what an earlier trademark means, especially that it's one that could be well known in a member state in the sense of the Paris Convention. If this reputation exists, the mark shouldn't be registered if it's identical with or similar to an earlier trademark, irrespective of whether the goods or services for which it's been applied are identical with or similar to those for which the earlier mark has been registered, where the trademark would have been applied for would take unfair advantage of or be detrimental to the distinctive character of or the repute of the earlier trademark. So that's the legal framework that we have. And then we come up with the Massey case. The background to the case is that the holder of the earlier trademark Massey lodged an action of invalidity, considering that the contested trademark Massey, with two I's, was filed in bad faith. The Boards of Appeal declared that the invalidity of the latter, since it was acknowledged that the earlier trademark Massey, with one S, was well known by the relevant public at the time of filing and during the subsequent years. Now, assessing whether the date of evidence for determining the well-known character of a trademark is significant as regards to found a claim of invalidity, the court said that the well-known character of the earlier trademark must be established on the filing date of the contested mark, which relies on formal evidence and can't be presumed to have been subsisted if there's no proof until the date of that action is brought. Therefore, it can't be claimed that a prestigious but historical mark, which in fact was filed in the 1970s in the field of racing bicycles, has a sufficient surviving reputation 40 years later. So here we see the importance of the timeline of exactly how long the mark has existed, when it was actually well known, and when the other mark was applied for. The court added that a well-known status requires a higher degree of recognition of the mark than that required to establish a reputation. And also the situations in which the reputation of the sign can be regarded as generally known fact may be a factor indicating that the existence of the applicant's bad faith, so whether there's a certain similarity between the mark at issue and the earlier sign, such as a historical trademark, which is still well known by the public. Here we come to two marks, one of which is relatively well known, and the assessment of whether the earlier trademark has a reputation, which is an essential step in examining whether Article 8.5 of the regulation is actually acceptable. Now, a vague hypothesis regarding the reputation isn't sufficient, but a definitive decision regarding the acknowledgement of reputation with a specific level of strength is actually necessary. So the application of Article 8.5 requires the office, the EUIPO, to take a preliminary position on the degree of reputation of the earlier mark, and the complete dissimilarity of the goods or services covered by the mark with a reputation and the concessive mark isn't sufficient in itself to exclude the possibility of free riding or harm to the reputation. Now, the degree of reputation of the earlier mark is a factor to take into consideration when determining the fulfillment of certain requirements of bad faith, such as whether the relevant section of the public makes a link or connection between the two trademarks, and whether the use without due cause of the trademark applied for would take an unfair advantage or be detrimental to the distinctive character of that. So it's therefore an important step to decide on the degree of reputation. Also, whether the public concerned by the goods designated by the earlier mark and the public concerned by the goods or designated by the mark applied for are distinct. It may be necessary to take into account the strength of reputation of the earlier mark in order to determine whether that reputation extends beyond the public concerned by the mark. And even if there's no direct link between the goods designated by the marks at issue, the finding of an association with the earlier marks could still have been possible if the Boards of Appeal had properly taken into account the degree of reputation of the earlier mark and the stronger distinctive character of an earlier trademark, whether inherent or acquired through use, which has been made of it, the more likely that confronted with later or identical or similar mark, that the relevant public will call the earlier mark to mind. So the dissimilarity of the goods designated representatively by the marks at issue, class 7 on one side and classes 25 and 28 on the other, isn't therefore a sufficient factor for excluding the existence of a link between those marks in the mind of the public. Complete dissimilarity of the goods and services isn't sufficient to exclude the application of Article 8.5. And we know this because of the possibility of the harm to the distinctive character where it might be used, which could be capable of arousing association with the goods or services for which it's registered. This also refers back to the Massey case discussed before. Regarding the detriment or harm to the reputation, such detriment is made where the goods or services covered by the mark applied for may appeal to the public senses in such a way that the earlier mark's power of attraction is diminished. So a detriment to the reputation can still be present where the goods or services are dissimilar. And thirdly, the concept of unfair advantage taken of the distinctive character or the repute of the mark, so meaning the free riding, concerns the risk that the image of the trademark with a reputation or the characteristics which it projects are transferred to the goods or services covered by the mark applied for. So the possibility of free riding is still present where the goods or services are completely dissimilar. I'm going to miss this one out because there's more interesting things to come, I believe. This was more or less covered by the Puma case in any case. I'd like to move further on to marks with reputation to cover some more areas of this. So here we're talking about the reputation resulting from use in a different form from that of the registration, and in particular in the form of another registered mark. Here we've got obviously two shoes in class 25. Now, as the reputation acquired by one trademark relies on the evidence of its use, the owner of a registered trademark is entitled to present any form of evidence to make out proof of particular distinctive character and reputation of that mark. And in this case, the court confirmed that reputation can be established through the evidence of its use as part of another trademark or combination with it, as far as the components which differentiate the two trademarks don't prevent the relevant public from continuing to perceive the goods at issue as originating from the same undertaking. So here the court went further and extended this principle to the acquisition of a reputation resulting from the use of the sign in an amended form, especially in the form of another registered mark presenting a very close visual proximity as far as the public would be inclined to attribute the same origin to both of the signs. Again, marks with reputation here taking unfair advantage of repute again. And this might be supported by evidence of actual commercial use and the assessment of whether the use of a slogan for commercial purposes was meant to take advantage of the repute required by the earlier mark. Here the court said that the risk of free mark riding can be supported by evidence of commercial use, in particular when it refers to the earlier mark by suggesting a link to its repute, and therefore would influence consumer behavior on purpose. For example, as they would make a connection with the quality of the products distributed by the earlier trademark. In these circumstances, the actual use of such marketing strategies have to be banned as far as they were meant to be taking advantage of the reputation acquired by the earlier trademark, and therefore creating such a link in the consumer's mind would be detrimental to the conservation of its repute. You can see here 2 stripes are not enough, contrasting very nicely indeed with the 3 stripes that we saw on the previous slide. In the So case, here we had the trademark So, which had established reputation for cosmetics in class 3. And the question was whether the likelihood of confusion is this a requirement to determine whether there's a risk of tarnishment for a trademark with reputation, in particular if the same degree of similarity is required to consider the detriment caused to the repute of the earlier trademark. The scope of protection given to a trademark with reputation is broader than the principle of speciality, which is commonly applied to prevent from any infringement arising from a sign affecting an earlier right. Therefore, a specific protection is provided to an earlier mark as far as any form of evidence is brought to substantiate that it has already acquired a reputation, meaning a finding of reputation doesn't always require evidence based on market shares or opinion surveys, but could be acknowledged as the result of proof relating to the important presence of the sign on the internet. The application of such protection requires the examination of a certain degree of similarity between the signs, And all the relevant factors of this case have to be examined to consider whether the contested mark suggests a link with the repute of the earlier one and would impact on the consumer's behavior, as well as the nature of the products, the degree of its distinctive character, and the strength of reputation of the earlier mark. Now, the existence of conceptual, phonetical, or visual similarities with respect to the reputation acquired by a trademark can evidence a risk of association between both signs. Therefore, the establishment of such a link when using the mark at issue is the only requirement to determine whether such association tarnishes the repute of the earlier mark. Nevertheless, we do have to bear in mind that the link to a trademark with reputation may be established where there's a low degree of similarity between the signs. Even though there's no likelihood of confusion. So determining a likelihood of confusion is not a requirement for finding such a link. However, the use in commerce requirement for the contested mark must be fulfilled when there's an effective risk of tarnishment affecting the repute of the earlier trademark. So in conclusion, the argument upheld by the court seems consistent with the foregoing, since the mark "so bioetic" for bleaching and cleaning products will cause undesired and negative associations to the detriment of the earlier mark "so", which has been acquired reputation for cosmetics. And moving on to a last case, which I think is all we're going to have time for today, we have the Skykick case. Here, this was a case where three questions which were actually posed to the court. Firstly, whether a trademark can be declared invalid on the grounds that the specification lacks clarity and precision. So we're looking here at the list of goods and services. And if the answer to that question is yes, whether terms such as computer software can be considered to lack clarity and precision. And finally, if a trademark can be declared invalid wholly or in part on grounds of bad faith, if the applicant had no intention to use the mark in relation to some of the specified goods and services. The three questions were then answered by the Advocate General, who said that in answer to the first one, a trademark can't be declared wholly or partially invalid on the grounds that the list of goods and services lack clarity and precision. He considered, remember this is the Advocate General's opinion, that the term computer software is too broad and that therefore registration for this would be unjustified and contrary to public interest. And in answer to the last question, that the application for a registration of a trademark with no intention of using it is in connection with the specific goods and services may constitute an element of bad faith, especially when the objective of the applicant is to prevent a third party from entering the market. These were the answers of the Advocate General, which were quite worrying. The consequences were quite large because if the specification lacks clarity and precision, we might actually have a large number of invalidity actions. Also, it casts doubt on the acceptance of relatively broad terms, which might actually therefore change classification practice. In fact, when the court came back, it came back with answers which were slightly against this. The answer to the first question, whether the trademark can be declared invalid on grounds that the specification lacks clarity and precision, the answer to this was no. It can't be declared invalid on those grounds. Given the fact that the answer to the first question was no, it didn't answer the question relating to computer software. This means that we don't actually have to change our practice as far as this is concerned. And in answer to the third question, whether a trademark can be declared invalid on grounds of bad faith if the applicant had no intention to use the mark in relation to some of the goods and services applied for, the answer is yes, that it can actually form grounds of invalidity on bad faith, but only if the applicant had the intention of undermining the interests of third parties or obtaining an exclusive right for the purpose of fulfilling that fulfills the functions of a trademark. This was a very interesting one, which basically defined the whole of the idea of clarity and precision in the list of goods and services, and whether this could be, in fact, a problem. So these are some of the cases which we've been dealing with recently. I hope that they have been of interest to you. I hope that they've covered the areas that you are interested in.